So, welcome everyone to protect your loved ones through estate planning. I think a lot of you already know us, but I'm Tiffany Chin. I run the Tiffany Chin Group with Rachel Bijo and Beatrice Hannon here. And we wanted to bring on this estate planning webinar for you guys because it's important to us that even beyond when you guys have worked with us on a single transaction or multiple ones, we want to continue to take care of you. It's important to us that you're protected, your loved ones are protected, and that we continue to provide value for you. So today we have attorney Bahar Geslin here who will break down what you need to know to responsibly pass on your assets, avoid unnecessary taxes, and create a secure future for your loved ones.
Hi, thanks for having me.
Of course. Thanks for joining us.
Like Tiffany mentioned, my name is Beatrice. I'm an assistant on the team. I've been with the team for about a year and a half, and I love this group of women, and I'm very excited for us to talk about this today. We have a lot to learn along with you. So, just to go over some of the things we're going to talk about today, we'll talk about what estate planning is and why it matters, the consequences of dying intestate, probate basics and how to potentially avoid it, and legacy planning strategies. But obviously much more. If you guys have questions, feel free to drop them in the chat and we'll try to answer those as well.
Yeah. Thanks, everyone. Thanks, Beatrice. So, Bahar, let's dive into it. So, how did you get started with Shalon Law and why did you enter this field of estate planning?
Sure. So I have been doing exclusively estate planning with my own law practice for over 10 years. This year will be year 11. And it's definitely when I was a little girl, I did not dream of being an estate planning attorney. I had no idea what that was. It's not even something I thought too much about. It's a required class for the bar exam, but beyond that, I was going to be a litigator, and that's how I was trained. And I finished law school in 2008, and we all had to pivot. And I started working for a firm where they did all kinds of law. I did criminal, civil, bankruptcy, kind of everything under the sun. And I did some probate and estate planning as well. And then I did that for a few years, and I had my first child. And I was let go the day I came back from parental leave. So lawyers are the worst offenders of the law. And I took some time to think about of all that I had this great fortune of practicing many, many areas. And I thought, what do I like the best? And I was drawn towards, estate planning. It's like my clients were happy at the end of it. They were giving me hugs. I was providing a service. It was something proactive and part of like being organized, all things that speak to me and that I love. And it also spoke to me as a new parent and a new homeowner. I just felt really connected to it. And I was doing a parent ed class with my son. And at the beginning of the class, they were like, we want a nutritionist, we want a realtor, we want a financial advisor to talk. We want somebody to talk about what happens to our stuff and our kids if something happens to one of us. And I was like, oh, that's called estate planning. And I could do like a 101 on that. So I did a estate planning 101 talk similar to what we'll be talking about tonight. And at the end of the class, several of the parents came up to me. They're like, well, can you do our estate plan? And that's really how my practice was born.
We're now
Yeah.
together, huh?
Yeah, I was like, hold that thought. And I got some liability insurance and hired a paralegal and it really made a lot of sense because at that time the offers I was getting were to, basically never be with my family and never be at home. It was like we had bought this home, we had this kid, and I was never going to see any of it. So it felt like a good fit for me, and it's something I've, you know, sometimes you don't know what you're getting into, and it's a good thing, but it's grown into I don't get the Sunday blues. I love going to work. I love what I do, and I love my clients. So I'm grateful of how it all unfolded.
And that makes us so happy to hear. And we can dive into this a little bit deeper later, but you've worked with several of our clients and friends already, and they adore you. So Thank you so much for all that you do to protect our clients and friends, families. It means a
Thank
lot.
you. Yeah. And I've said this to you all many times, and you all are here because you trust this amazing team of women, but you really are looking out for everyone's best interests. And I'm so excited. You'll see, I love talking about this. I love talking about the pros and cons. It's not ever one shade, right? It's not a binary like yes or no. There are lots of everyone's situation is slightly different. Keeps my job exciting, but we all need to protect ourselves. So I just appreciate so much how much you all value that.
So Bahar, you kind of touched on this, but can you just give everyone like estate planning? We keep talking about estate planning. What exactly does that mean? Like, what is it?
Yeah. It's a term of art, right? Like it can mean different things to different people, but it's like we all have an estate. I know pretty much all of you that are here are homeowners because you've worked with the Tiffany Chin Group in purchasing a home, and maybe you have multiple pieces of real estate. So, but whether you have property or not, a home or not, we have an estate. And the law gets involved, a court will get involved based on the size of that estate. So if you don't own real property, which doesn't apply to any of you, or if you have less, so let me say that in a different way. If you own real property, or if you have more than, let's say, $200,000 in gross assets, so not taking into account debt, liability, or anything, and you pass and you don't have a trust, okay? Doesn't matter if you have a will or any other documents that you've heard of. If you don't have a trust and you pass, your estate will go through probate. We have these different court systems. There's family, civil, small claims, traffic, right? Et cetera, et cetera. And we have probate court. And that's where your estate, whatever size it is, if it meets that threshold of real property, doesn't matter if there's a mortgage again, where it'll go for a judge to oversee it and make sure it's going where it's supposed to. Maybe you say, but I have kids, and it's just like, obviously it goes to my kids, right? It's like, it'll get there. It'll get to your kids, but it'll take years because right now, even the simplest probates are pushing a year. And then it'll cost money because there are statutory fees assessed on the gross value of the estate. So if your home is worth $1 million, and it doesn't matter if there's an $800,000 mortgage, probate fees are assessed on the gross value. So that could be like $40,000. It'll get to your kids. It'll get there, but it'll take years and it'll cost $40,000, $50,000. The way to avoid probate court is to have a trust. So again, in California, some of you may be from different countries or different states. This is very specific to California. People are always like, you're lying. This can't be true. This sounds like excessive, but I promise you, this is the law in California. If you own real property or you have more than 180 some thousand in gross assets and you don't have a trust, doesn't matter if you have a will, your estate goes through probate. So back to your question, Rachel, of what is estate planning? I like to describe it like this. We have this universe called estate planning. At the center of that universe is the trust, which is why I spent so much time talking about it just now. I like to think of that as the sun. And then you have all these other documents within the estate plan that orbit around the trust. The will, powers of attorney, health documents. We'll get more into those in a few minutes, but you can think of the estate planning universe. At the center of it is the trust. And then you have all these other things that support it. The trust makes sure that should you pass, your estate goes where you want, when you want, and how you want. You nominate someone to be in charge of it. That's the trustee or the successor trustee. Otherwise, it goes directly to your legal heirs. I mean, if you have a will, you can dictate where it's going. It'll still go through probate court, but you could say, I want it to all go to my favorite charity. And it'll get there, but it's going to go through the court to get there. And so the trust allows you to avoid that. And because you've nominated this trustee who's in charge and who you're saying, we trust this person to be in charge and we don't need judge for you to get involved. Thank you so much for your service to everybody else, but we've taken care of our business. The other big thing, I know this is going beyond your question, Rachel. I'm going to pause because I'm getting really excited to tell you about this, but
that is okay.
yeah, let me just finish my thought on the trust and then I'll pause, but to see if we have any questions too. But in the Tiffany and her team are the best they are. The trust, what I want to stress is like, we don't know when we're going to die, right? It could be tomorrow. We hope it's in a very, very long time and that we have time to prepare for it. But as we all know through life experience, through our family, friends, things we hear, that's not the case, right? So we have to plan for this inevitability, but not in a fearful way. We want to do it when we're calm and not stressed. What is like, we're all going to die, but what's becoming more and more likely in this generation, in this season of our universe, I'll say, is our incapacity. The statistics are that 3 out of 4 of us will need some type of long-term disability care. The trust also addresses your incapacity. So it says, okay, if I die, this is where it's going. This is when I want them to get it, how I want them to get it, who gets what. But the incapacity portion is really not looked at closely enough and super, super important, because as I walk through people's families through this, you don't have it well written to deal with their incapacity. That's like, I'm alive, okay? But now I want someone to use my money, my assets, to take care of me. If you don't, there's no other document to convey that other than a trust. It's not the will. The will is a dormant document. Nobody looks at it until you die. It's not a power of attorney. We'll talk about that. I mean, ish. It's not your healthcare directive. Who do you put in charge to take care of you if you're alive with your money? So that's also addressed in the trust, part of the estate plan. That's why it's not called like a death plan, because your estate is living. It exists while you're alive. You want your loved ones to be able to use your assets, whatever they are, to take care of you, one, so that you're not a burden on them and that they have access to it. Let's say I know some of you are thinking, well, gee, I don't have a trust. How does my family do that now if I don't set one up? They have to, again, go to probate court and get a conservatorship. There have been a lot of really exciting movies in recent times about conservatorships and people misusing it. And I'm here to tell you, it totally happens. It's not, it's not just made up. It's not Hollywood. So again, the trust allows you to really bypass this court system where you don't have any control and you're paying a lot of money that's all coming out of your estate to say what your wishes are.
Makes sense. So I think you already touched on it, but are there any other upsides that we should be thinking of if we do plan our estate in advance?
Absolutely. I want to answer Drew's question because I think it's timely and before I forget, and then I'll talk about that. So what is the role of the executor? Is that just another name for the trustee? Kind of. So we have the trust and we have the will. The executor is usually somebody that's named through a will. It's also known as a personal representative. And the trustee is the person that you name within the trust. If I'm creating a trust, the Bahar Trust, and I'm alive and I'm healthy and well, I'm going to make myself the trustee. So I'm the trustee and I'm the creator. The creator is also known as the grantor or the settler. So I'm the trustee of the Bahar Trust. I put my home in the name of the Bahar Trust. And then I say, if I become incapacitated, Rachel is going to be my trustee. She will be the trustee of the Bahar Trust, not the Rachel Trust, the Bahar Trust. Then I say, but if I die, I want Beatrice to be the trustee of the Bahar Trust. She's going to make sure my taxes are paid, that, she gathers all my assets and then gets the money to my beneficiaries, in a timely manner. That's the job of the trustee. So Rachel would be my trustee, taking care of me while I'm incapacitated, making sure, like, do I need to sell my house to be able to pay for, a a living situation or for rent somewhere and use the equity in my home to provide care? Or is it good to rent out my house and use that income because my mortgage is paid off and we use that income to pay for my care? Or maybe have a ton of cash in the bank, which I hope is the case when I get to that point, and then uses that to take care of me and bring people into my home. So make the decision also to how is it's best to use the assets for my benefit. Okay. So
As a follow-up, actually, I have
yes, please tell me.
can you name your trust something other than just your name?
Oh, okay. Great question. Yes, you can. You can name your trust the Sesame Street Trust or the ABC Trust or whatever you want. And there are instances where this creates confusion and chaos where it's not necessary, because you have humans looking at documents, and it's much easier to understand that Tiffany Chin is the trustee of the Tiffany Chin Trust than it is, Tiffany Chin, the trustee of the Sesame Street Trust. Like, what is this about? They want to ask more questions. They want to see a copy of the trust. So it's not impossible, but it does create another layer usually of questions and paperwork. That said, I have a lot of clients that are either politicians or judges or just high profile, and they don't want to be on public record. So what we create for them is what's called a blind trust. It's pretty simple in the sense that we create this trust. It would be, let's say Beatrice doesn't want to be on public record. So her business manager, Rachel, or her CPA or accountant or whoever is willing to step into that role, her attorney maybe, it's going to be Bahar Geslin, trustee of the, Sesame Street Trust. And then as soon as the title is recorded on the home, we switch it to, maybe I'm her trusted advisor anyway, so we keep it as Bahar Geslin, trustee of, the trust, or maybe she just changes it then to Beatrice, but it's not on public record. The deed doesn't get recorded. An interesting thing about deeds is that as long as they're signed, they are legally enforceable. They just have to be recorded at some point. So they don't actually need to be recorded. Of course, you're recording your deeds when your house is purchased because you want to make sure that it's actually in your name and it's recorded. But once the seller signs the deed, it's actually the property has been transferred, whether it's been recorded or not. So that's where we'll do like a blind trust. Now, sometimes people come to me and and I have a friend like this, who's high profile, and they already own their home, and then they became a person of interest. And I said, well, we can certainly change the name of the trust and take you off as trustee, but there's already that chain of title that exists. So it's not it doesn't provide complete anonymity. But if you're making a new purchase and you don't want to be on title and you're willing to incur the extra expense of creating a blind trust and like the questioning that will come with it from banks, and that's the other thing with lenders. This is a good time to talk about this. I'm sorry if it seems all over the place, but I'm sure some of you are thinking, well, yeah, how does that work if I'm recording title in the name of my trust and I have a loan, right? I have a mortgage in my name. This is a non-event for banks and county assessor's office. Your property taxes will not get reassessed. It's a non-taxable event, transfer to a trust, and they will not, it's actually illegal by federal and state statute to call a loan due to a transfer to a trust. As long as the owners are the same or married or relatively the same, the loan will not call due. So if, I know like Rachel and Joey, we were talking about that, like you own your home and you want to transfer it to the Rachel and Joey trust, property taxes stay the same, loan stays the same, nothing happens. So that's something really important to know about a trust, is that the only thing that changes when you create a trust is that instead of taking title to your assets in your name as an individual, you're going to take it in the name of your trust. And that way it links it to the trust. Otherwise, you continue to spend your money the way you spend it. It's not a corporate entity. You don't have to file a tax return for it. Not until you die. Like then it'll have its own tax return, right? But as long as you're alive, it's just business as usual as it pertains to your assets.
So since you brought us up, I'm gonna jump into one of my questions that I have. So I'm pretty sure almost everybody on this call knows I have a husband. We do not have a trust set up, but we do own our home. So what do we need to be thinking about? Because I think I always was of the mindset, we don't have a will either, but I was like, oh, if we just get a will and we decide who to leave the home to, that should cover us. But now I'm learning that is not the case. So what should we be thinking about? Because I know a lot of our clients too are married and or have partners that they're going to be getting married to that don't have trusts set up.
Yeah. I mean, you need to have an estate plan. That's just to keep it really simple, because again, the trust is going to deal with your permanent incapacity or death. Great. Mm-hmm. I say oftentimes people's weakest link, if you will, is not having the incapacity document set up. So a durable power of attorney. Beatrice, I don't want to jump the gun because I know you mentioned to me you might ask me some questions, but okay, we'll leave that to the side. But like, let's say, Rachel, you want to speak to Joey's employer, or Joey wants to speak to yours, to HR, to pull money from one of your retirement accounts. The fact that you're married doesn't give you any authority to do that. Absent a power of attorney, you can't do any of those things. The power of attorney says, I give this person the authority to be my agent, attorney in fact, if I am incapacitated. Very important, because we don't realize you essentially can't do anything without that document. You can't talk to the bank. You can't talk to Social Security. Like, even think of your parents, right? A lot of us might have like aging parents or relatives. And you're like, well, I have their passwords to everything. That's really great. That's technically illegal. Maybe no one will ever find out, right? But like, the day you get locked out of the account and, you need to call and do some banking, they're going to start asking questions. Do you have a power of attorney? Make sure you have a power of attorney for all your love, or not that you have it, but that like they have a power of attorney nominating somebody to conduct business. Anything from like getting bank records to talking to the mortgage company. You want your person, your key person, whether that's your spouse or not, you're not in a position to do so, and you want them to decide, like, should we rent the house? Should we sell the house? Like, should we pay down the mortgage? Like, all these things. Should we take money out from 401k, or should we take it out of our investment account? They are going to need to talk to your financial advisor. Maybe they want to talk to your realtor. They can't do it without a power of attorney. So that's a very important document. I only do comprehensive estate planning. That means, like, if you need a trust and you come to me and say, Bahar, I heard in the talk you did that it's really important to have a power of attorney. Can you just do the power of attorney for me? To say no, because I think it gives a false impression of security, and I don't want that liability, and you shouldn't have it. Just do everything and do it properly. That's sort of my shtick, and get protected. And it just also is not efficient, or like doesn't pay to do it piecemeal. So don't do piecemeal planning. So I think your first step is to sit down with an estate planning attorney. What I usually ask of clients or potential clients is, and sometimes people think I'm being nosy, and it's like, I promise I'm not, and you'll understand that. And I don't think any of you would feel that way, because you're coming from like, we share trusted people in common, right? But it's like, I want to know, do you have a home? How much do you have in retirement? Do you have life insurance? How old are your beneficiaries? Are your beneficiaries your little kids? Is it your great aunt who's in her 80s? Like, I want to know this stuff because, first of all, I want to determine whether you have a taxable estate. I want won't talk too much about taxes. Right now, California is not subject to any state estate tax. So state death tax, you can think of. We don't have any. Washington has it. Other states have it. California does not. We are only subject to a federal estate tax. The number just changed, so I'm going to look it up. But the federal estate tax is, okay, it's 13.61 million for 2024. If you're married, you can double that. Let's just say 27 million for ease. So in English, in plain English, what that means is you can pass on as an individual up to $13.5 million of wealth before the government takes any tax from that passing on of wealth. And then that's probably in the 40% bracket. So you can pass on 13 million or 14 million, and then anything else you pass on, let's say you have a $15 million estate, the next generation would pay 40% tax on 1.5 million. And then again, if you're married, that doubles it. So most of us are not dealing with estate tax. I do have, quite a few clients that do, and we spend a lot of time and resources avoiding estate tax. That's a whole nother game. So if you're in that category, certainly it's something that we can talk about. But if you're not, and you're not anywhere near that, then we just concentrate on, making sure that we don't trigger any property tax reassessment from one generation to the next, and kind of think about minimizing capital gains as well.
Well, really good to know. So we thought we would throw a few scenarios by you, if that's okay.
Yeah.
So I'll start with my scenario in case it's relevant to anyone else. So I own a condo and a single family home in my trust name. So I had put together a trust before. And then my sisters and I own investment property under an LLC name. I believe it goes back to the trust, but I'll have to double check on that. So now that I'm newly engaged, what should my next step be with estate planning? Is there something else I should do? Or is it complicated?
It's not simple, but it's something that is best to think about sooner rather than later. Because these are difficult. They can be difficult conversations to have, but they're better to have them now. So I happen to know that in addition, like, you just got engaged, congratulations, but you didn't buy your house that long ago. California is, so that's good. I like that. California is a community property state. That means that anything you earn or acquire during your marriage, so from the second you're married, is community property. Okay. There's no mine and theirs. Everything is ours, absent a prenuptial agreement. So we're just going to put prenuptial agreement to the side. Because that of course changes things. So then let's say you bought this house, you put a down payment on it, right? That's your separate property. Separate property, I should define as anything that's pre-marriage, earned or acquired, and anything that you inherit. So a lot of times my clients, they're like, we started with nothing, we got married, we have everything's community property, then boom, somebody inherits something. Well, that's technically separate property. It depends. Some clients are like, well, we share everything. We're just going to put it into our family trust account. Great. Other times they're like, we share everything, but I also want to make sure that if I kick the bucket, this doesn't go to their new partner, right? I want it to get directed to my beneficiaries, whether that's kids or a sibling or whomever, right? Favorite charity. So we'll create what's called a separate property trust. So your existing trust might be a separate property trust. And then you're going to create the new Tiffany and Matt trust. And then you'll have to decide. I mean, that's more like advanced planning that we would talk about, because now once you're married, you're going to be contributing your respective incomes to the family home. That's slowly getting transmuted, that's the technical term, or changed to community property. But you also have this big chunk of money that you put in that was your separate property. So there's no one answer, no one way to do it, but it's definitely best to have the conversation and decide now what that's going to look like so there's no confusion. And what we call commingling of assets, because once you commingle them, then you have to detangle them. No one's detangling them unless they're getting divorced. Nobody wants to think about divorce. The statistics are that more than half of us should be thinking about it. I used to be a family law attorney and work for a family law judge, so I'm well aware of it. But you know, just a quick conversation now and some planning can help avoid it. That's where forensic accountants get involved, and your friends and colleagues are like, oh, when they're like, how's the divorce going? They're like, the worst, the nastiest. A lot of times it has to do with the detangling of those assets. Yes, I want to give well, another thing is like when you get married, and I see Herman, you asked a question, I'm going to read it in a second, but like starting fresh with things, like if you've been contributing to an IRA or a 401k and then you get married, it's good to think of those as like separate, like now I'm going to open a new one because this is now my community contributions. So just sort of like creating that line in the sand. That doesn't mean you're putting things in separate sand pails. It's just like, okay, this is the new fresh start. But your old trust is going to be irrelevant in some sense because you know, I don't want to put you on the spot, but like you might want to be thinking about having different healthcare agents, right? You didn't have that person in your life when you created your trust. So maybe a lot of things are staying the same, but you want somebody else, you know, making health decisions if you're not able to than who you had before. So those are also things that may not affect the trust, but affect the overall estate plan. Okay, I'm going to read Herman's question.
And then
In my,
Ella has a question too.
oh, sorry.
Ella has a question also.
Oh, okay, let me do
there's
that one first.
Yeah.
Once your kids inherit your estate via the trust, do they have to keep it in the trust and they become the trust owner, or do they inherit it in their name and the trust gets devolved? Oh, great question. So it depends on what we say in the trust. Like I have little kids. My kids are 13, 9, and 5. They're not getting anything in their name until they're in their mid to late 20s. And it's getting spaced out. At some point, they'll get it all. Like if they're 30 when my husband and I died, they'll just get their 1/3 share. But before that, they have to go to the trustee and say, I would like to use my portion for tuition or to purchase a first home or for healthcare or lodging. I use an ascertainable standard called Health Education Maintenance and Support, also known as HEMS. It's a very broad standard. So do they have to keep it in trust? That depends on what we decide. Do we want it to be held in trust and managed by a trustee for a certain amount of time, or do we want to give it outright? It depends on the age of the kids and what their relationship with money is like. I have some clients that say, you know, this kiddo is great and we want them to be the trustee. And then this one, you know, really needs more hand holding because they'd use it to hurt themselves, or they would use it, you know, they wouldn't be wise with it. And we want to wait till they mature more. Something I think about and talk about with my clients is, what does that look like for your child's relationship? So in another life, I was a psychology major. And in addition to this estate planning, right, I also do trust administration and probate. So when I'm telling you probate takes, you know, in a year and a half, 2 years, the simple ones, and this is how much it costs, it's because I was in probate court this morning. Like I'm living this. I also do trust administration, which means when the grantor passes, the trustee, whoever the successor trustee is, they now have a fiduciary duty. They need oftentimes an attorney to help walk them through, like, okay, now we need to send notice to the beneficiaries and we need to do the tax return and give notice to the franchise tax board and like all of these things, usually in more complex estates. So I've seen, you know, grief and money it's like a funny chemistry experiment and we just don't know. It's different every time. And everyone grieves differently, and everyone, like all the resentments that were bubbling under, they don't go away when mom and dad die or auntie dies or whomever. Like they are at the surface. So I always ask my clients, like, especially if their children are close in age, do you think it would be a good experience for your kids to inherit their money together? Like, or like, I just think it would be odd if you're close in age. For some families, like my sibling got, just came into several $100,000 and I have to wait 2 years for mine. Maybe it's something that could bring them together and not create this separation. And then they can, compare notes with like, what are you doing with, which financial advisor are you using, or how are you investing your money, and kind of like experience receiving that legacy together. So that's something I think about, that's sometimes appropriate and sometimes it's not. It depends on the situation. That's my long-winded answer for that. Okay. Herman, in my scenario, I'm not married to my partner, but we own a house together. Does that add any complications if we want to put our property and other properties we separately own into this trust? Follow up, is it better? Okay, so yes, not knowing all the facts, and I'd love to sit down with you and like learn about the facts, but just off the top of my head, I would think it's appropriate for you each to have your respective separate property trusts. And then you'll take title, if it's 50-50 ownership in your respective separate property trusts. Title is so important. And I know that you all at the Tiffany Chin Group get these questions a lot. Like, title's asking me how to take title. I don't know. Like, tenants in common, joint tenants with right of survivorship, married with right of, like, what do we do? And it really is good to consult with an attorney, because when you unravel that, it can have like severing a joint tenancy if you don't have the same owners, like doing all of that can create property tax reassessment, which we don't want, and capital gains issues. So you want to be very thoughtful about how you take title in the first place and work with somebody who knows what they're doing for when you transfer title to the trust. But so the properties you own separately, you should each have it in your respective trusts. The property that you own together, maybe title is transferred to your respective trust 50-50. Drew, since the trustee trust bypasses the court system to a degree, what entity oversees the trustee carrying out the wishes of the deceased? Is there some kind of periodic check-in by the state? No. It's implicit in the word trustee. It like choose somebody you trust. It's really tough, right? So of course there is some, I'm just like giving you the short answer, but if there's somebody's doing something nefarious, they can take the trustee to task and take them to court and, ask for, there's transparency in the sense that they have to provide an annual accounting and reports to the beneficiaries. Also, when somebody dies, the people that get notice of the trust are within 60 days, they're supposed to get notice from the trustee, and who gets notice? Not only the beneficiaries, but any intended beneficiaries. And then there's a 120-day contest period. All of this, the trustee has to provide them a full copy of the trust, and then they get to poke at it and ask questions because we want there to be transparency. So if, I get calls from people like, my parent died and I just found out I got a copy of the trust and I read it and I see I'm not getting anything, or I'm getting like a very nominal amount. And is there anything I can do about it? And it's like, well, if you think there was undue influence or fraud, then there's possibly something you can do, and let me refer you to a litigator. I don't do that. And if not, you just, we're allowed to give our estates to whom we want, when we want. It's very hard to disinherit a spouse of community property, and it's very hard to disinherit a minor child. But other than that, there's no like oversight committee. Sometimes people choose to nominate co-trustees. I hope that I get an opportunity to speak with all of you, and I can tell you why I'm not a huge fan of co-trustees. It's appropriate in very rare situations, but the example I generally use is it's often hard for two people to decide where to go to dinner, let alone how to manage assets together. So I've not seen it go well. I have heard of it going well in some instances, but I've only seen it like end in litigation or severed relationships and wasted money. I'll tell you that, because every time the trustee has to do something, and if they're represented by an attorney, it costs the trust money that's coming. Like, that's what I try and explain to my beneficiaries that are fighting. Like, choose your battles, because do you want to spend $10,000 in attorney fees fighting over $5,000? And I'll tell you, and this is where I say grief and money are tricky. Like, oftentimes the answer is yes. They're like, have an axe to grind. Like, this is important. This is not about the money. This is the principle. So,
Principal.
having a well-drafted trust, a foolproof trust. And that's why, like, I don't know if I'll get this question eventually, but like, why do there's LegalZoom, there are these DIY things. Why can't I use that? I mean, you can, and maybe it'll work out for you, but generally they're not, they're fill in the blank, right? So there's nobody asking the questions and thinking about the pros and cons of things and the relationship between people. So they usually end up not working out and being ambiguous, and then people fight. So they either drain the funds or they end up in litigation. I'm in litigation on 3 LegalZoom documents right now.
Oh, that sounds like fun.
But I've also seen it in 2 scenarios, like, be very appropriate, just like they didn't have anything and it was going to their next of kin anyway, and it just worked out. Okay, if you don't have children now but have them in the future, would you recommend waiting to make an estate plan after children are in the picture? Excellent question. No, if you meet that threshold of you own real property or you have more than $184,500 in gross assets, you need an estate plan. Because again, who is going to use your assets? Like, your family is going to end up in probate. Now, we can write the trust such that it goes to any future descendants. And then if you don't have any future descendants, these are your beneficiaries. So I do that all the time. But you got to have a plan, because you want to say where it's going. Maybe you don't want it to go to your next of kin. Who's in charge? And then not put your family through that, or have people step up to take care of you or to take parts of your estate that you don't want or you didn't intend to. So I don't think it's a good idea to wait. There are times where people are pregnant and we draft everything, get everything ready, and right after they have the baby, then we sign the documents so we can include their name. That's okay. But other times people are like, I really don't want to be talking to you after when I have a newborn. And I'm like, I am not offended. I would not want to talk to me either. So they are okay with us just signing before the children and having it be like an anonymous, like a sort of descendants, a blank name. But no, if you own real property, you got to have a plan. Like what I talked about before, maybe you weren't on, like, it's not just the trust, it's also the power of attorney. Feel like this is a good time for maybe your question, Beatrice, because I'm eager to talk about it.
Yes, I was ready. So
Okay.
for my situation, I currently rent, so I don't have a trust, I don't have a will, I don't have any of that. So where should I even start thinking about estate planning?
Yeah. So we can still have a conversation, right? Because maybe you still meet that threshold or you're close to meeting that threshold. The only person I've ever done a will-based plan for was for a friend of mine who's a monk. And like, their deal is to not ever have any assets, but they're a professor. And so they just, like, whether they want it or not, they have stuff, but they want to make sure where it goes. Like, they want it to go to their Zen center and their temple. But other than that, like, it's not like you have to wait till you click into that category to have it. Maybe it's not a priority for you though. You're like, God, it's, it costs money, it takes time. So you still, what to do and what you're working towards. But I'll tell you, I had a situation, I got a call over the holidays, a frantic call from, I don't even remember how they were referred to me, but a niece who lived in Canada, and her uncle lived in Los Angeles, and he was renting and he passed, and he just has a brother in Canada. And so this is like the brother's daughter. And they couldn't get into the apartment to even see if there was a will or a trust because they didn't have any documentation Do you know what I mean? So it was like they were really stuck. A power of attorney would be so helpful there. Now, technically, a power of attorney is only valid while you're alive. You can't give agency over yourself over a dead person, right? But any kind of documentation in that situation would have been so helpful. They had to go to court to get an order just to let them in the apartment. So now you may get an apartment manager that like knows your family, has seen them visiting you, and they're not they're not strictly by the book, and they let them in. So it could work out, right? But you want to think about who can talk to my employer, if I'm in a pinch, if I'm having a situation and I've been putting money in an IRA that I could take out in an emergency or take money out of my savings to pay my rent or my bills or my health care or whatever, who has the authority to do that? So again, maybe in your situation, depending on the exact facts, you could wait. But here's the beauty for all of us about having an estate plan. Let's say all of you are homeowner. Well, Beatrice, you're going to be a homeowner soon. So let's say you say, Bahar, I don't have a home, but I'm saving money and I'm earning and I want to buy a home. Should I just wait till I have a house to create a trust? And the answer is you're building towards a down payment that's going to be converted into equity of a home. So in either situation, whether the asset is in the form of real property or the asset is in form of like savings or an investment account, it needs to be protected. And it will go through probate if it's not in the name of a trust. So, and then once you create the trust, you don't have to update it every time you open an account or buy real property. Let's say some of you, like, I forget who it was, one of you said like you have investment properties. Tiffany, I know you do. You know, investing in real estate is amazing. It's a great investment. You don't have to update your trust every time you buy a new property. The only thing you do is when you buy that new piece of property or you sell your current home and you buy a new one, do you need to update your trust? No, it's a living trust. It continues to grow with you. So you just make sure that when you acquire the new asset, you take title in the name of your trust instead of your name as an individual. So instead of taking title in Beatrice's name, you're going to take it in the Beatrice trust name. Same thing with investment accounts or savings accounts. You take it in the name of the trust, and then it just grows with you. So you can, like I said earlier, it's business as usual. You buy and sell real property, you open accounts, you close the accounts. It's, you know, it's a great business plan for attorneys if you had to come to us every time you changed anything in your assets, but that's not efficient. So you just continue to live your life, invest, grow, thrive, flourish, and when you take title to something, you do it in the name of the trust. Now, you asked something, Tiffany, that about an LLC. Oftentimes, real property, especially investment property, people take title in an LLC. You want to make sure that the LLC's agreement, like the operating agreement, the agreement that dictates what happens, how the membership works, who gets what, says what happens when one of you dies. Like if it's not explicit, then everyone's left looking at each other. Does it go to the other members? Does it go to your family? Does it funnel to your trust? I like to make sure that shares are owned by the trust, especially if it's like, sometimes it's, you know, two people, they have an LLC together, they own the place together, and it's just like, it's a shell, right? So in that case, maybe it's not that it doesn't matter, but it's less confusing. But if you own it with siblings, that can be really confusing. If some of you are married or getting married, you may want your portion to go to your spouse and not go to your other siblings. Or maybe the deal was and always with that this will always be named like owned by by us, like with siblings. But then what happens when you all start having kids? Do you still want it to go to your siblings or do you want it to go to your children, right? So you have to make sure that it's written and it says what that is. It's clear we need to have a clear plan, clear directions, right? Okay. Generally, what is the cost range of drawing an estate plan? If you're single, I would say expect to pay around $4,000. If you're married, 5,000. It depends, but that's generally the range for a good plan. If my parent purchases a home and transfers it into a trust of which I am the trustee, would I directly be able to claim depreciation on the property to offset my W-2 taxes? I'm not giving you tax advice, JVT. I don't have any to give you. Please talk to your CPA. I don't know. Or would the title need to be transferred to me? Would there be fees involved other than attorney fees for this? I don't know if you're talking about a transfer upon their death or a current transfer. But regardless of it, call me, okay? But regardless of what it is, this is such a great topic because some of you may have parents or you may yourself be thinking, what? I got the one asset, I got the house, I got the person I want to go to. Why don't I just put them on title, right? Why don't I transfer, or like in your case, JVT, and I don't know if this is what you're necessarily saying, but like if it's going to me, well, you said you're the trustee, which does not make you the beneficiary. The trustee just means you're in charge of the asset, not that you own the asset. So, but maybe you meant beneficiary, but just know that those are two distinct things you can have. Like, remember in my example, I made Beatrice my trustee, but I love you, Beatrice. My kids are my beneficiaries, and my husband. So, so it's not one and the same. And oftentimes, especially if you do have minor children or you don't like your family, your trustee may not be the same as your beneficiaries. Yes, it would be while we're all still alive. And yes, I believe I meant beneficiary. Okay, cool. You don't want to transfer real property. It's better to inherit it because of something called a step up in basis. I know I just told you I wouldn't give you any tax advice, but Google it. I mean, that's general. When you inherit the property, you get the value date of death. So let's say your parents bought the home at $500,000, and when they pass, it's worth $1 million. When you go to sell it, it's worth $1.2 million. You pay capital gains, 40%, on $200,000, the difference between the $1 million date of death, 1 million date of death value, and the 1.2 million sale value. Okay. If you transfer it now, you don't get a step up in basis. You're going to pay capital gains on the difference between the purchase, like the other side. So don't do that. Also, property taxes will absolutely immediately get reassessed. That is considered a sale, a transfer. It is not a non-taxable event. It's only a non-taxable event if you inherit the property. Prop 19, additionally, you need to educate yourself on that too. Means that when you Prop 19 was confusing. It was like more money for firefighters, and we were having a lot of fires. So everyone voted yes, and it passed by a very small margin, 51%. I'm not here to talk about politics. I'm just here to tell you that it made it such that you can only maintain the property tax value on a home you inherit if it was your parents' primary residence and you make it your primary residence. This is very limiting. I had a client last week who told me they have to sell a property they inherited because they can't afford it with the increase in property taxes. The rent they're getting with the mortgage that's on it doesn't equal to any income, so they have to sell it. So that's also something. Don't do estate planning via deed. It's just never, everyone would do it otherwise. So it doesn't pay to do it. I hope that answers your question. All right. Any other questions or?
Did we cover everything we wanted to cover, team?
Oh, I have a question. Bahar, what should I be looking, if I'm considering an estate planning attorney, what should I be looking for?
Other than me, Rachel?
Besides you. I mean, I would choose you in a heartbeat. You asked me to ask this question.
What to look out for in an estate?
What should they look out for?
Yeah,
honestly,
no, for sure. Definitely. I mean, I would say somebody that has like a tried and true process is one thing. Let me tell you, this is very emotional. Maybe it's been on some of your to-do lists for a while. Maybe you didn't know you needed to do it. Okay. So you're like, oh, let me come to this webinar. And maybe it's been on your list or at the back of your mind. It's very emotional and nobody really wants to think about dying. So working with somebody that has a tried and true process is important. Over the past decade, I've seen where people get stuck. And one of the promises I make is to get you through the process. We estate plan for tomorrow. We estate plan for if something happens to us tomorrow. That's kind of like, I think, Helen, you asked, like, should I wait till I have kids? No, because you still have an estate and we need to know what the plan is for tomorrow. We can always change it, amend it. It's not written in stone. So having a process where you can move through it with them and it's organized, I think is important. Obviously, the experience is, that they have experience in this area. I've come across all kinds of plans, amazing plans, badly written plans. A lot of times, well, I'll just tell you what I do instead of what people don't do. I don't want to stick you with a worksheet or a questionnaire and be like, hey, fill it out and come back to me. I want to go through it with you. I'm going to be asking you questions. You may not understand the question, let alone how to answer it. So I'm going to explain it to you and we're going to do it together. So there's a lot of like hand holding in that sense. I don't need to watch you enter addresses and phone numbers, but we're going to talk about like, okay, you want to name your sister, as the guardian of your child, your minor child. That's great. Are they married? Do you like her spouse? Do they have kids of their own? Is there a likelihood they're going to move away for work? Or sometimes it's appropriate for people, they want to name their parents because they're older, but sorry, I was reading Helen's question and I lost my train of thought. What was I saying?
You were saying that sometimes they want to name their parents, but their parents are old.
Right. Like in my case, I'm very close to my mom. She's with 2 of my kids right now. If I'm thinking estate planning for tomorrow, she's the most logical person to be guardian. We didn't really talk about that. If you do have minor children, one of the big things we'll be talking about in estate planning is who you're naming as guardian for your minor children if you and the child's other parent are no longer alive. Maybe that's your spouse, maybe that's not. Very important, very difficult. I'm asking you to tell me who's going to replace you if you're no longer around to take care of your child. That's an impossible question. And it's a really unfair question. So I don't ask you to decide that. I ask you for like next best and we like go through that. But yeah, so for a parent, maybe you're like my parents. Well, okay, is that your mom or is that your dad? What if your dad's no longer around? Is your mom still able to handle it and vice versa? So we really get into the weeds of like, I don't know your key players and I don't get to decide. I don't get to have an opinion on that. But I'm going to ask you probing questions. And I think someone who does that and challenges, like, tell me a little bit more about that. Tell me more is good and would probably be a good fit. Okay. Helen asked a question. Does estate planning process change by state? If I look into this for my parents and they live in another state, yes, you should find a licensed attorney in the state where they are a resident. Absolutely.
Okay. Well, this leads us to my next question. So, going back to what we said in the beginning, like our group is just we want to make sure that our clients are taken care of. All right, Bahar. Well, thank you for joining us today.
Thanks.
And thanks everyone for logging on. We know it's a Tuesday evening and you already had a full days of work and childcare and everything else in your life. So we appreciate you and we will see you next time. Have a good night.
Night.
Thank you. Bye, everyone.
Bye, everyone.